Once upon a time, it was difficult to monitor someone's movements. To know where a person went, one generally had to physically follow them around. A person could freely meet with whomever they wished, and there was no easy way to keep track of who was spending time with whom. If government officials wished to know where their critics lived, worked, or met, that meant relying on expensive and often illegal surveillance. Advances in technology have changed this. Today, most adults carry smartphones. These devices allow us to keep in touch with everyone in our life everywhere we go. They give us pinpoint accurate maps that can tell us where we are and how to get where we're going. It's hard to pass up that kind of capability. But although for legal purposes you own the physical device, big tech companies like Apple and Google own the software, and that means your phone effectively works for them. It collects and reports data about you every minute of every hour of every day. And while all phones do this to some extent, Google takes exceptional advantage. They too find it hard to pass up the capability of smartphones. If you've ever used Google Maps, Google Assistant, or other Google apps, whether you're on iOS or Android, you've probably been asked to enable location services. Google says that this lets them keep track of your location so that they can improve their services to you, such as by offering you things like more relevant suggestions and maps or better targeted advertisements. In point of fact, what this actually means is that Google will record your location hundreds of times per day and save this forever in a vast database called Sensorvault. Sensorvault contains the exact whereabouts of millions of people on a minute-by-minute basis as they go about their daily lives. Empowered by this data, Google can infer nearly everything about your life: where you go, who you're with, what you like to do. They can combine this with things like your calendar, your search history, and your YouTube browsing and your emails to learn what you're thinking, what your desires and ambitions are. Google can use this information to improve the quality of its suggestions for video and search results. But on the downside, vast data warehouses like Sensorvault can be analyzed for any purpose whatsoever, and the end users whose data is contained within them have no real say in how or any knowledge of when. In 2016, Google received a warrant from law enforcement demanding to know the identities of everyone located within a specific area during a specific time. This was the first in a practice known as Geofence warrants. In a Geofence warrant, the government names a location, a time range, and a search radius, say 150 meters around a bank for the 30 minutes before and after a bank robbery. This boundary is the so-called Geofence. When you're using Google Maps, you may have noticed that Google can often pinpoint your location very precisely, and often to within just a few meters. So if you're standing at an intersection, your smartphone can probably tell which corner you're on. This accuracy costs a lot of power, and if Google relied on that level of precision 24/7, battery life would be greatly reduced. So when you're not actively using Maps, Google uses lower accuracy data to log your location as you go about your day. This creates a lot of imprecision and makes it hard to pinpoint a user's exact location. In this case, your smartphone can only tell very generally where you are, maybe to within a couple hundred meters. In that case, Google can only provide a ballpark estimate of which part of the city you're in at any given time, and it only checks every few minutes. So at any given time, Google establishes what it refers to as a 68% confidence interval for a user's location. Think of this as being a circle on a map, with Google being 68% sure that a user is somewhere inside that circle. When Google has very clear location data, this circle is very small. But when the data is less clear, like when the phone is locked and in your pocket, the circle can be hundreds of meters in diameter. When Google processes a Geofence warrant, it asks law enforcement to undergo a 3-step process. In step 1, Google identifies everyone in Sensorvault whose 68% confidence interval places them within the geofence. It then provides anonymized data showing the locations of each device within the area to the requesting law enforcement agency. So for instance, law enforcement might ask to list users who were within 150 meters of a bank at 2:30 p.m. on a specific date. Google then provides a list of anonymized identifiers for each device, along with information about their confidence intervals, the region that Google thinks each of those devices were likely to be in at that time. The police then are supposed to identify which of these devices seem most relevant to their search and present a narrower request for the users they believe are most likely to be relevant to their investigation. In Step 2, Google provides enhanced data for this narrowed set of users, showing their movements for an extended period of time beyond the original search. This data is no longer limited to just the area of the geofence. So for instance, if in Step 1 we generated a list of everyone who seemed like they might have been within the 150 meters of that bank, then in Step 2, we're looking for more information about where those people were in the hours before and after the crime. That information is no longer confined to the geofence. So, for instance, imagine you were driving down the street in a time and place that happened to be covered by a geofence warrant, and law enforcement decided that your movements seemed relevant to their investigation. Google would then provide the police with a detailed account of your movements, showing the places you came from and went to, whether they were inside the search radius or not. At this time, Google does not provide identity information. However, there is nothing stopping police from using other information sources to identify people. In Step 3, law enforcement is supposed to narrow their query again and identify the specific users who should be de-anonymized. That is, which users should have their personal information given to the police for further investigation, such as being brought in for interrogation or subject to additional surveillance or search warrants. Understandably, this is a very powerful tool for law enforcement. Google processed its first geofence warrant in 2016, but by 2020, Google processed over 11,000 geofence warrants and estimates that geofence warrants account for 25% of all warrants Google processes. These warrants can be very broad in their scope. For instance, the FBI requested GPS data for everyone in the vicinity of a Black Lives Matter protest in which Molotov cocktails were thrown at the headquarters of the Seattle Police Officers Guild. Although the FBI has an obvious interest in arresting arsonists, this geofence warrant would have provided the FBI with the movements of potentially thousands of law-abiding citizens engaged in nothing more than lawful, organized protest of their government, not to mention many more who simply happened to be in the area at the time. From this, the FBI would be able to infer valuable information about where these people meet, live, or work, despite having no probable cause to support such an invasion of their privacy. This is precisely the kind of overreach the Fourth Amendment seeks to prevent. In fact, a person does not even need to be within a geofenced area for law enforcement to receive their name. Because Google is only 68% sure that a user's location is within their confidence interval, roughly 1/3 of the time they will not even be in their reported location at all. Nevertheless, their information may be surrendered to law enforcement, involving them in a criminal investigation into a matter they had no connection to whatsoever. There is, however, a ray of hope. In March of 2022, U.S. District Court Judge M. Hannah Lauk, presiding in the Eastern District of Virginia over the case of United States v. Okello Chaudhry, made a ruling that may set a new standard for how geofence warrants are viewed. Judge Lauk found that while Google does require users to affirmatively consent to participating in location services, it is highly unlikely that most users have any idea that Google is logging their location throughout the entire day in a vast treasure trove of data that can and will be used against them in criminal proceedings. And furthermore, the Fourth Amendment requires that warrants be supported by probable cause and be particular to the people and places they describe. A warrant that refers to everyone who had some likelihood of being in the vicinity of a crime constitutes a search of everyone whose data is affected, Judge Lauk said. This would require the warrant to be supported by probable cause that each and every person whose data would be affected was involved in the crime in some way, but those warrants don't do that. Nor do these warrants seem to limit themselves to the particular devices that will have probable cause to be connected to the crime in some way. Therefore, she says the Geofence warrant is unconstitutional, and she expresses skepticism that any Geofence warrant could ever be constitutional. In her ruling, Judge Lauk displays a firm grasp of the issue and identifies the root cause. Quote, "This case has arisen because no extant legislation prevents Google or its competitors from collecting and using this vast amount of data. And as discussed below, despite its ongoing efforts to improve, Google appears to do so under the guise of consent few people understand how to disable. Even with consent, it seems clear that most Google users do not know how the consent flow to control their collection of data works, nor do they know Google is locking their location 240 times a day. Thoughtful legislation could not only protect the privacy of citizens, but could also relieve companies of the burden to police law enforcement requests for the data they lawfully have." End quote. If this line of thinking carries through, one would hope to see a similar ruling from the Supreme Court, as well as privacy-protecting legislation from Congress. In the meantime, however, we must be cautious. This ruling is only from the Eastern District of Virginia, and therefore, most people will not be protected by its reasoning. And it could be the case that a higher court will find against this logic. And even if a solution were found for the entire United States, that hardly protects people in dangerous regimes that have far fewer protections. Judge Lauk is correct that the problem has arisen not because of what the government is doing, but because of what Google and other tech companies are doing. For so long as dangerous treasure troves of data like Sensorvault are permitted to exist, they will continue to be abused to the detriment of ordinary people all over the world. This has been a CipherSuite briefing. I'm Jonas. If you enjoyed this, please make sure to like, subscribe, and share, and leave a comment below. Besides making sure you'll see the latest content, this will also help CipherSuite grow. Thank you very much.